Right. We will hear the next two cases together, with each side being given 30 minutes to argue. The cases are C-24-0295 and 296, Courtney and Colbin versus Durrani.
Good morning, Your Honor.
How much of your 30 minutes would you like to reserve?
I doubt I'll use all 30, but let's say 7, just in case.
All right.
It'll, I think, depend on the court's questions more than my presentation. Good morning, Your Honors. Aaron Herzig for appellants. May it please the court. This court's recent precedent in these cases relating to Dr. Durrani ends with a harmless error analysis. You have found errors. Several of those errors occurred in this trial following your precedent. They clearly are errors. The question ultimately will be whether those errors were harmless, at least in this court's precedent. And clearly they were not in this case. What this court has looked at is, are these quote unquote close cases? Is there strong expert testimony on both sides? What is the nature of the testimony? What did closing arguments rely on? Here, as you read the record, you'll see that both with regard to Mr. Colbin and Mr. Courtney, who were tried together, which is one of the errors we assign, these were close cases. In fact, both plaintiffs get better after surgery. Mr. Colbin goes from a 9 out of 10 pain before surgery to a 4 out of 10 pain after surgery. Mr. Courtney is able to get off some of his medications and start back to work. Importantly, too, neither plaintiff followed post-trial recommendations, post-surgery recommendations from their physicians. They did not engage in the physical therapy and rehabilitation necessary to fully recover.
There was competing evidence, though, wasn't there, about whether physical therapy would have helped them at all?
No, I don't think that's accurate, Your Honor. And I think even the trial court, to the extent appellees make argument in their response brief, and there wasn't much, their argument is that it wasn't required. It was only, quote, recommended, which would imply that physicians somehow have the ability to force their patients to undertake therapy, which of course they don't. The physician's orders were do physical therapy, stay out of work for a while, make sure your back gets better.
Well, Dr. Wilkie, as I understand it, said that he normally does not recommend physical therapy as a routine post-op recommendation. He doesn't see the benefit of it in the absence of an identified motor deficit.
And I think it's Dr. Kalustian on our side, the expert, who talks about the fact that the failure to do physical therapy is in fact what was problematic and could have led to this problem. In addition to, of course, the other injuries that were sustained. In Mr. Colbin's example, he went back to work earlier than recommended. He got on a Bobcat, he crashed the Bobcat, he had other injuries, all of which came in at trial. What I'd like to focus on are 3 things that are relatively new in the case law here. One is consolidation. You've made one decision on the consolidation of these trials in a case called Jones and Conley. The second issue is the comparative negligence instruction, which we believe should have been given here. That's a new issue for this court. And the third is, you mentioned Dr. Wilkie. Dr. Wilkie's ineligibility to testify because he no longer practiced medicine clinically for 50% of his time. So with your permission, I'll start there, and then if there are questions about the other issues, I'm happy to address them.
I think you had said that you believe Jones was wrongly decided.
Yes.
And I would love to hear why.
Sure. We also think it's very distinguishable on these facts, and your honors can look at that if you're not comfortable overturning a decision from another panel. We haven't decided to go en banc with that yet because maybe we need a different decision in order to do that. On the question of it being wrongly decided, we're unaware of any we have not found a case, appellees have not cited a case, you all have not cited a case outside of southwestern Ohio where medical malpractice cases against a physician are ever consolidated. And I think that makes a lot of sense. I don't think there's a blanket rule that you can't. Maybe there should be, because think about how individualized these decisions are. Every medical malpractice case will deal with the individual history and medical conditions of the particular plaintiff. It will deal with the particular procedure or operation or diagnosis.
So are you asking us to create a carve-out of the joinder rule for medical malpractice actions?
I'm not going that far, although I think it wouldn't be an unreasonable rule. But no, today what I'm asking you to do is to decide that these medical malpractice cases should not be joined, and that Jones is wrongly decided for very similar reasons. The first of which, by the way, is that the trial court itself never made a Rule 42 determination. There was no motion to consolidate. It simply asked, and this is in the supplemental materials that we've been adding on the Densler case, it simply asked plaintiffs to come up with scheduling of various trials. And defendants objected to that. Plaintiffs came up with cases that are essentially the same location in the back. And that's basically it. So you have the same defendant, which is true in a lot of cases, same lawyers on both sides, same location in the back on which the procedure occurred. And that is basically the entirety of how the judge decides to consolidate these cases.
And so was
In
there like
Jones-
was there like a limit to the number? Like that there would only be two?
No, now we're at 3,
Or-
Your Honor. When
Okay.
we filed the writ of prohibition in this court, it was when they moved from 2 to 3, because no, there is no limiting principle.
So it's
that comes out
just
of
the
Jones.
same location in the back, and it could be 10?
Under this court's precedent, there is no limiting.
Okay.
There's no limiting rule as far as we know. We think that's part of the problem. What Jones glosses over is first and
What
foremost.
would be the source of a limiting principle? I mean, if we were to agree with you that there should be, like, I don't know, maybe 10 is the limit, maybe 80 is the limit, I don't know, but where would we get the limiting principle from?
So I don't think there should be a limiting principle based on the number. The limiting principle should come from Rule 42 and what are common issues of law and fact. And what I would submit to you is that that's awfully hard to find in a medical malpractice case because of the individualized nature of medical treatment for the individual person receiving that treatment. Imagine colonoscopies. One doctor does hundreds of colonoscopies every year. Same part of the body, basically the same procedure. In fact, it's preventive medicine. A lot of insurance covers it. Every person over, I think now 45 is supposed to get one every 5 years. So there are hundreds of them per physician. Not everyone has a perfect outcome. So under the Jones analysis, a plaintiff's attorney could wait to gather up a couple of colonoscopies every year from any particular physician and bring them in a single trial based on the facts that we have here, because it's the same part of the body and the same procedure.
And why would that not be a common fact under Rule 42 and the Rule 42 case law? Why is a medical procedure and this carve out that you're describing, why can that not be a common fact?
Well, I think part of the reason why you don't see that in the case law is that all of the other, even if you have, it depends on the level of generality at which you're going to work. At some level, every tort case has common law. Every negligence case has the common law of negligence, so that's a common law. Every fraud case is going to have a common fact of a statement that someone reasonably relied on. We have no history in American jurisprudence of being able to pull together every fraud claim. So that level of generality is obviously too high. We think the level of generality here was also too high because because of the individual, it's really a sense of the individualized nature of each of these things outweighing what the common law
So are
and
you
facts
then
are.
proposing, I mean, it seems that we're inching towards a class action type standard. Are you proposing that we should be scrutinizing this common question of law or fact through more of a class action lens?
I think they're not dissimilar, Your Honor. I think when you start to read cases about common questions of law and fact, they're not dissimilar. So it's a different rule, but a similar lens.
So you told us why Jones was wrongly decided,
Yeah.
but how is it distinguishable?
Sure. Thank you. I would, again, part of, I think, the thing in Jones that needs to be corrected is the failure of requiring the trial court to do the analysis in the first part, and we think that's reversible on its own. This court shouldn't be making the Rule 42 analysis in the first instance. That should have been the trial court, and there isn't one. Why are they different? What this court found in Jones and Conley were very similar, similarly situated plaintiffs with similar histories, and then similar procedures. You relied on the same experts making the same testimony. Here we have really very different plaintiffs. Mr. Coblin injures his back in 1988 playing and is no longer able to play baseball as a high school student. So back in high school, injures his back, re-injures it in 1989, continues to have problems for many decades, tries lots of doctors, different conservative care. Ultimately, I think in 2012, when his pain is 9 out of 10 and it's radiating into both legs, he can only walk for 15 to 20 minutes. He then goes to see Dr. Durrani, who recommends surgery, followed by physical therapy. His pain was a 9 out of 10 before surgery and eventually ends up at a 4 out of 10. Mr. Courtney, a very different history. He doesn't start having back problems until he's moving houses in 2009. He falls and passes out in 2012, goes to see Dr. Durrani, has one injection for pain.
So where do these differences that you're identifying factor into the Rule 42 analysis? Because by its plain terms, the rule directs us to look at common questions, not different questions.
So, that's part of where I think the court before got it wrong, because it did seem to rely on some of those facts, and that's where we distinguish. So if Jones is correct, we would distinguish it based on the same terms that Jones was decided on. But I agree with you. I think that there aren't really common questions of law and fact here, because we're at too high a level of generality for understanding what common questions of law and fact really are. The Tayyab testimony, the Dr. Tayyab testimony, which this court has ruled is error, just by way of example. He talks about hearing in hearsay, third hand, that Dr. Durrani told people that their heads would fall off. Well, there's no testimony in these cases about any of that. So how do you join those two cases if there is a case where there's the head falling off comment versus a case where here in both cases he does say, I can fix you? Arguable whether that's a problematic statement in the first place. But in one case, he tells Mr. Courtney, hey, if you don't do this, you might end up in a wheelchair. He never says anything like that to Mr. Coblin. So even if we're getting to some of the material facts about what the representations were, they were different here. This gets to the comparative negligence question also. You might have situations where the jury it just so happened as luck.
Isn't this a reasoned judgment that the drafters of the rule have contemplated? I mean, isn't this the risk any time cases with common questions of law or fact are consolidated? Because there's always going to be differences. No two cases are fully identical. And so there are going to be risks that a different fact in one might prejudice the parties in the other. How do we account for that?
I think you look for cases where that's not going to happen. I mean,
so you believe we are required to consider differences?
Yes, I think.
And what is the authority for that rule?
Excuse me, Your Honor. Sorry.
What is the authority for that? What requires that?
So I think due process requires that. I think all of the rules of evidence require that. If your consolidation is going to unfairly prejudice one of, or potentially both cases, then those are limiting factors too. You can't just look at Rule 42 in a vacuum and say, common questions, I find a common question, therefore I can consolidate. We don't have any precedent for cases like that. So here, let's say you have a situation where, and it's just lucky that both of these, lucky is the wrong word, but it was fortuitous for the purpose of this conversation that both plaintiffs didn't do, in our view, physical therapy the way they were recommended to do physical therapy. But if you have a case where one person did and one person didn't, we don't know that going in because we haven't had a Rule 42 analysis to look at what is the same and what is different. And then we might have the jury learning that they need to apply comparative negligence for one plaintiff and not for another. And so I really do think it's where these things, when you fit all of these things together, you need to ask yourself, are the common questions of law and fact going to get us to a fair answer to these questions? We can't just be throwing cases together based on the fact that the procedure happened to be the same.
So you're saying you haven't found any cases that join medical malpractice cases together?
For individual, you will see them in like a medical device case. There'll be a class action typically, and one of the claims will be a medical malpractice case, something like that. But no, in terms of an individualized treatment scenario, you have this Sayuda case out of this court that's from the late 80s, I think. Judge Barrett in the federal court has joined trials in Atwood. That case has yet to be reviewed by the Sixth Circuit, and now your case in Jones v. Conley. But when we scour the world for cases like this, we don't find them. Appellees have never cited one. This court did not cite one in Jones.
You scoured other state decisions and federal
Yes.
decisions, and you haven't found any situation where medical malpractice cases like this have been joined?
We have not. It's been a little while, but we have not.
Okay.
And I would say even if there were, that doesn't comport with the way the rule should work and the way the law should work, because there is such a risk of unfair prejudice here. Medical malpractice is a very personal thing. I mean, look, we have two punitive damages verdicts in this case that are exactly the same. Each plaintiff received a $750,000 punitive damage award. To me, that's really strong evidence that the jury pulled these things together.
But the verdicts were different, though.
They were, that's right. They made some differences, and you will hear in later cases that every once in a while you'll get a defense verdict. This is not always fatal. That doesn't mean it's not error. And what I would tell you is the same punitive damages number is really good evidence that they were looking at this physician based on multiple cases and not the individual actions that he took in a particular case.
So you say that about the punitive damages, and I get what you're saying, but doesn't the fact that the jury reached different decisions on the compensatory damages claims, doesn't that cut against what you're saying?
I don't think it, like I said, Your Honor, I don't think it does. There are certainly, there are instances when juries, especially when you're talking about, medical damages awards and what different people spent on treatment, things like that. But there's also a second piece where they, I think it was the loss of enjoyment, where they got the same number twice. They each got the same number. I think it was $70,000. So I think there is a fair amount of evidence that there was a lot of overlap. Did the jury work pretty hard and try to treat these things a little differently? There is some evidence of that. But the question ultimately is, was there unfair prejudice? Were there really common questions of law and fact at the right level of generality that this could proceed? And I don't think you see that here. And I think the rule in Jones and Conley is a problem. Even if you were to decide that this case was similar to Jones and Conley and these two plaintiffs were similar enough, I would still argue that I would not follow Jones and Conley. I think we need a different rule for consolidation in cases like these. I'd like to spend a minute on comparative negligence, the comparative negligence instruction, because that is new in these cases. Comparative negligence.
Could you speak to what evidence in the record, from your perspective, established that the plaintiffs, what I'll just characterize as failure to fully complete physical therapy, caused their continuing pain and immobility?
So that would be a jury question if they were allowed to consider it in terms of the instruction. We have testimony from the expert witnesses on that point, and we have direct testimony from them that they did not complete the physical therapy. It was recommended by their physician. They chose not to proceed with that, and in fact, Mr. Koblin went back to work and injured himself on a bobcat right away. So it's awfully difficult to see how his actions, instead of resting, instead of doing physical therapy, sustaining a new injury, weren't something a jury should have considered in the comparative negligence instruction.
Would your experts have had to be more explicit that the plaintiffs would not have suffered but for their decision not to pursue physical therapy? I mean, I don't know if your experts even got to that question. They just said, yes, it was recommended, they should have done it, but does there need to be some sort of proximate cause?
I don't think so, Your Honor. I think, and I think the jury could have inferred that in any event if they were instructed. If they were instructed, hey, if someone doesn't follow doctor's orders, that's something you need to consider in your verdict. I think they had sufficient evidence to do that.
To make the jump between somebody did this and it caused this, I mean, that doesn't seem like an inference that a layperson can make.
So I think when you read the entire transcript, my read of the entire transcript is that there was sufficient evidence for them to understand and do all that, and we of course argued that.
How would the jury have known? Can you point me to what someone would have said to enable the jury to make the comparison between what the plaintiffs were saying was a surgical failure or surgical problem that contributed to their long-term pain and immobility versus something that they did that contributed to their long-term pain and immobility?
Well, again, I'll mention the expert testimony saying that they should have conducted the physical therapy. The question of whether it goes far enough is a different question, and you're right, Your Honor. So I'm looking at the instruction again. The instruction we proffered was that it contribute as a proximate cause. So that I think that answers the question you were asking for, and we think the evidence was there for the jurors to reach that conclusion. Because you have the fact, I mean, including the injuries that occurred afterwards. I mean, at that point you have, I think, a very obvious understanding for jurors that, hey, wait, something else might have caused this continued injury. So that's what I would point to. And you know, look, we think reversal makes sense to put that instruction in, have a fair trial with each individual plaintiff, and let a jury decide whether in fact there was comparative negligence or not. The last issue I'd like to spend time on, because I think the court has basically addressed the others as errors already, is Dr. Wilkie's not being qualified to testify under Evidence Rule 601. In Johnson v. Abdullah, which started in this court and then was affirmed by the Ohio Supreme Court, it was very clear that under Evidence Rule 601 in place at the time of this trial, Dr. Wilkie had to be practicing clinical medicine for at least 50%.
If we agree with you on this point, do you agree that the amended rule would apply on remand?
I haven't thought about that, Your Honor. It may. I have not thought about whether that would apply.
Is there evidence in the record as to what Dr. Wilkie's clinical practice standard was as of the time of these surgeries?
We wouldn't dispute that at the time of the surgeries he was practicing medicine. This comes up because he
standard,
stops.
right?
Yes.
He meets the standard as of the time of the surgeries, just
Yes.
not as of the time of the trial.
Right. But I don't think this court could decide not to reverse because the statute, because who knows if it gets amended again before whatever date this trial happens. So I think.
But if it applies, then Dr. Wilkie would be qualified to testify on a retrial.
Potentially, yes. I haven't thought about it enough
Right.
to know for sure and to think about it. I'm sure my colleague will have a different opinion on that if he's thought about it. But all you have here is the trial court saying, well, I think he stopped because of COVID. But we're in September of 21. Life is basically back to normal, certainly in the healthcare field in September of 21. And he clearly doesn't meet the threshold. There's no evidence that he did. I think it's conceded that he was not practicing at the 50% level in September of 21.
When
And Johnson
was
v. Abdullah.
trial originally scheduled in this case? Or if COVID hadn't have existed, when would this trial have occurred?
I don't know, Your Honor.
Okay.
But that would be an exception. The court relied on that idea, the idea that, if this trial had proceeded, he would have been. But Johnson v. Abdullah, again, from this court and then affirmed unanimously by the Ohio Supreme Court, says very explicitly the statute means what it says, and you measure it at the time of trial, because that's what the statute said. We now have this amendment that the court has mentioned that changes the time, but at the time, under Johnson v. Abdullah, an expert witness had to be practicing at least 50% of his clinical time at the time of trial, and that
But the
simply
court
wasn't
applied
the
the
case here.
Selmer exception, the Selmer v. Rogers exception to this.
So Johnson v. Abdullah in the Ohio Supreme Court, limits Selmer to its facts, and the facts there were where someone intentionally stalled so that the witness would not be qualified. There's no evidence of that. If anything, the COVID idea suggests that it was no one's fault. But Johnson v. Abdullah, we think, is very clear. You got to apply the statute as written at the time of trial, and we don't think there's a way around that based on Ohio Supreme Court precedent, even if it turns out that after research and briefing on trial, Dr. Wilkie's testimony would be admitted now. The statute says what it says.
So if we agree with you and if we rule that Dr. Wilkie was not qualified to testify, it seems like a lot of the elements would be a lot more difficult to find absent that testimony. So if we agree with you, do we just send it back?
Yes, Your Honor. I think that would still. I think when you're looking at the errors here, you're really talking about a new trial at that point.
So, so Dr. Wilkie's testimony was not duplicative then of Dr. Saini or Dr. Taib, correct?
Correct. And Dr. Taib's testimony, we think, should be excluded under this court's precedent already. I think, and I didn't get into all the jury instruction that this court struck down in Jones, the Taib testimony, which I think is Stevenson and Hounshell. We have a number of errors here. In that situation where there is a close case where patients have gotten better, this court has reversed for a new trial. We think that's appropriate here. We think these errors clearly weren't harmless. Appellee offers no argument in their brief as to why the errors were harmless, other than to say they were. And so I think based on that record in this briefing, this court should reverse for a new trial.
And counsel, you're out of time.
Thank you.
Thank you.
A lot of papers,
Take your time.
a lot of necessary papers. But I feel like I need my crutches, Alan Snapman and Ben Moran here on behalf of the two plaintiffs. Good morning, everybody. And I think that I can answer a lot of the questions that you seem to have by going through a punch list that I just made while you all were talking. First, I'd like to point out that we've gone through 124 trials over the last 5 years, with about a year off for COVID. And the plaintiffs win 78.8 or 9% of the time prior to the cases that have been reversed and retried. Those are 9 cases that have been retried, 7 of which have been plaintiff wins for just about the same percentage, with the evidence that was pulled out by the Court of Appeals decisions. So whether Taib testifies or not, the plaintiff is still winning 80% of the time, for instance. The simplest one to address first is Dr. Wilkie. He was qualified at the time that he testified.
Counsel, let me stop you there. What I hear you to be advancing is a data-driven analysis of the harmless error question. Is that a fair summary of what you've just shared with us?
Well, that would be a fair summary of what I just said. It's not the only thing that I'm going to say as we go through.
Sure. Assuming that we would find something like that helpful, but recognizing that the information that you've just shared is outside of this current record, how should we go about considering that information in either this or any future case?
Well, I think that certainly we can start to include it in the briefing if that's necessary, but I think you can take judicial notice of the clerk's office's records and the verdicts that have appeared without them being incorporated specifically here.
Is that something that you're asking us to do?
It certainly would if you would find it helpful. I would certainly ask you to do that because they're just numbers and it's just math.
How would we, assuming that we're following you so far, how would we get to the point of understanding that the excluded evidence had been pulled out of the trial? Where would we find that information in a docket that we're taking judicial notice of?
I'd have to think about that, but I believe that it's clear that those appellate decisions were honored in the retrials. But I would have to think about how that would be something that you could find through judicial notice. But I will represent to the court, since I tried all of those cases, every single one of the 124 plus the retrials, that yes, your excluded evidence was excluded in the retrials. And I'll see what I can figure out about how to prove that without incorporating each one of those records into this record, which is already big enough, or the next record, however this ends up working out. But I thought that historically you should know what's going on and what brings us here today compared to what has been happening and what has happened with your prior decisions. The Dr. Wilkie issue is he was qualified before COVID, he was qualified after COVID. He lost his position during COVID because the hospital that he was practicing at not only shut down during COVID, but then lost its funding and did not have the ability to rehire him and has now ultimately closed. That is all in the record from Dr. Wilkie. He's been vaudeered by the defense counsel. He gives his qualifications. His qualifications are that he is teaching at Wright State and that he is working in a clinic not doing surgery, but doing orthopedic surgery consults and treatment. Only about 5 to 10% of orthopedic spine patients actually go to surgery. 90% of an orthopedic spine practice is non-surgical, as well as a neurosurgeon parrots that, somewhere between...
How do you guys get around the Johnson case, though?
I'm sorry?
For Dr. Wilkie, we have the Johnson versus Abdullah case from the Supreme Court, which is pretty strict.
Well, but let's...
How do you get around that?
How do I get around that?
Yes.
Well, the judge made a finding that this case would have been tried but for COVID. COVID is hopefully for all of us, a once-in-a-lifetime event, not something considered under any rule.
But the judge's COVID finding, he was using the Salmer v. Rogers case as the exception to the rule, right?
Well, no, not exactly. He was
Okay.
using that, but Dr. Wilkie was also qualified. He was in the practice of medicine, in his specialty, and teaching, which added up to more than 50% of his professional
Counsel,
time.
I don't think those facts are in this particular transcript. In this trial, he testified that he was working for an insurance company.
Well, he was also working for, this may have been the one case, you're right, where he was working only at United Healthcare during COVID. That was during COVID. After COVID, then he went into the teaching, et cetera. But the problem is, if you look at the rules that got applied to all of us, was an absolute stay of proceedings.
But wait, I just want to understand where you're coming from. Are you saying that there's evidence in the record that Dr. Wilkie complied with the rule, or are you trying to get around the rule?
I think Her Honor pointed out that that was during the exact COVID time where his only job was United Healthcare.
So that's this case?
Which doesn't qualify him under the rule.
For this case?
Except that we have COVID,
Okay.
we have due process, and we have the fact that the Supreme Court stayed everything, including statutes of limitations in many cases. So to say that we can take the Abdullah case and just wholesalely apply it to a, what was it, 118 years since there had been a pandemic that shut down the world?
You essentially want us to create a COVID exception to Johnson.
I think it's an obvious exception that should be created by all of the courts, just like the Supreme Court tried to fashion rules to stay litigation and bring that litigation
And
back.
why should we do that? Could you help me understand why we should do that for September of 2021? I mean, perhaps we could consider, I don't know, the March 2020 time period when the world is all but shut down. But why would we do that for September of 2021 when
Because-
things like jury trials were occurring?
Because that trial would have occurred but for COVID, and that was a specific finding of the judge.
Was there a trial date scheduled that got postponed?
I would have to go back to the trial, but the judge's belief was that this case would have been tried during COVID. You also have to remember that COVID came up at a time that we were coming towards the end of the schedule and starting a new schedule. So these schedules are not January 1st to December 31st, for instance. We may have a schedule that goes to March 30th, and then we've got to do the next schedule. And I did hear counsel talk about plaintiff proposing a schedule. Those are what we do. We were told to group them under the rule standard.
Counsel, I know you've referenced the standing order that was put on by the Ohio Supreme Court that kind of paused our legal system in the height of COVID. But is there any other authority that you can direct us to where, in retrospect like this, courts have set aside some kind of rule or principle or precedent on the grounds of COVID? Is there some authority that we can look to or some analog or something to give us security in creating this COVID exception to Johnson?
I did not look to see what others did. It appeared at some level to be obvious in terms of due process for the litigants that given the fact that the pandemic brought everything to a halt, and the judge found that this would have been a case that had it been tried during the COVID period of stoppage, he would have been qualified. The judge felt pretty strongly about that. Additionally, given the fact that the court has amended the rule, which ends up putting it right in that view that Judge Reese had, if you reverse it, there is no question. It's called a new trial under.
I'm going to stop you for a second. Aren't we required to apply the law that exists at the time?
Well, not if it's a procedural issue. The procedural issues change. And the issue related to the qualification of the doctor is at the time that he's testifying.
Well, the rule that was in place at the time that this case was tried said that that any expert had to be 50% or more of their time spent in that practice. That was the rule at the time. Are you saying that we should apply a different rule?
It's a new trial.
No, I'm saying us right now, sitting where we are right now and reviewing what happened in the
Oh, okay,
trial.
I see what you're saying. I believe that you can use it as a reference which is what you were asking me, where in COVID is there a reference? Well, we don't have a COVID reference, but we have a change in the law reference that says we're looking at doctors that were qualified at the time of the surgery, not at the time of their testimony. So I think that logic would dictate that you could do it, but if the case is reversed, the rule is going to be what the rule is now.
I understand that.
At that trial. And he's going to testify, and we're going to do it all over again. And we may end up doing it all over again because you find that something else happened that isn't harmless error. I personally disagree with that, and I'll tell you why as I go through
I'm going
the
to drill
rest
down
of
a
it.
little bit more on Dr. Wilkie. So if we disagree with you, and if we find that Johnson, since Johnson limited the Sellner case to its facts, and if we determine that the facts here are not the same as the facts in Sellner, and that COVID is not an exception that we can apply. So if we say that the trial court erred by allowing Dr. Wilkie to testify, would your clients have presented enough evidence or any evidence to meet all of the elements of your claims?
I believe so, through our other experts.
Okay.
Yes,
So,
I believe that we get to the finish line without Dr. Wilkie. We do have trials where Dr. Wilkie doesn't testify. We have trials where Dr. Bloomfield doesn't testify. Dr. Saney seems to be pretty much a fixture across the board.
he's a radiologist, though.
Well, he's a
Yes, I
neuroradiologist,
understand that.
and this court has ruled that given his expertise, he can testify on the ultimate issues. Did I answer your question?
Well, no, you didn't, because I was getting ready to answer another, or ask, slightly change my question. I understand that he is a neuroradiologist. I've dealt with these cases before, so I get that. My question for you, can he testify then that, whether the surgery was done properly? I know that he can testify in some cases that a surgery wasn't indicated, but can he testify to causation, for example?
Well, I think that he can testify if there's a mechanical issue that's a causation issue, a screw that has gone through the vertebrae and is hitting a nerve. But I don't remember off the top of my head at this moment. I believe Dr. Bloomfield testified in one or both of these cases. So Dr. Bloomfield's a neurosurgeon, and he covers the gamut, but I'll have to defer to the transcript because these start to run together a little bit for me, as you can imagine. But if Dr. Bloomfield's testified, he's covered it from the neurosurgical angle, and their expert that they alluded to, Dr. Kalustian, is a neurosurgeon. And that's why we have a neurosurgeon and we have an orthopedic spine surgeon, because in all the interrogatory answers pre-trial, they identified Dr. Durrani not only as the defendant and a witness, but as an expert witness. And their experts are neurosurgeons in all of these cases. We have a neurosurgeon, and then we have the orthopedic spine surgeon because of their identifying Dr. Durrani as an expert.
Thank you.
So let me drop back a second to this bullet point idea. And I heard counsel say when he got up, well, these clients got better after the surgery. No, they didn't. This is a common practice at the trial level, and we pointed out through cross-examination, it's replete in the record, that we could spend an extra week at trial doing the cherry-picking game. This record, a month after surgery, says they feel better. This record, 6 months after surgery, says they don't feel better. This record, a year after surgery, says they're having additional consults about either having to have a revision or that they're not surgical candidates anymore and they have to go into long-term pain management. So this idea that they get better, the expert testimony is clear. Everybody that goes through a surgery believes that they've gotten better for a few months after the surgery. It's what happens in the further months and years, because they come out of the surgery, they are on heavy medications, they are taking an extraordinary dose of opioids that is tailored to the pain level of the surgical process as well as the surgery itself, and then they tail off over time. In terms of looking at the issues in this case on consolidation, if you look at how Dr. Durrani keeps his records, and I have a laundry list, these are the same surgeries, the same type of surgeries, the same locations, the same experts, the same defendant. The records are almost interchangeable. He gets his operative reports wrong. He files them late, almost always. They are templated. They have the wrong people in them often. They are moved around, where if there's multiple procedures, because he's templated them, he's taking people in and out of the operating room 3 times to do 3 procedures during the same surgery. It's just not the case. But these are the kinds of consistencies that exist throughout these. His impression section, he lists 8 or 9 impressions. He almost always gets spondylolisthesis backwards. Their experts testify, well, it's not a retrolisthesis. I have to disagree with Dr. Durrani. It's an anterior listhesis. One moves forward, one moves back. That's where the bones are moving. It's a slipped bone, not a slipped disc. These things are in every case. Additionally, he says, and this goes to this issue of comparative negligence, after each patient, they come in at 2 weeks, they come in at 4 weeks, they come in at 3 months, 6 months, and a year. He says the same thing about every one of them, whether they went to physical therapy or not. They are doing wonderful. They are doing great. They are doing awesome. They are doing fantastic. They can't believe how well they're doing. That goes directly against, because remember, they tell, and you'll see it in every transcript, they tell the jury, you don't need Dr. Durrani here. You have everything you need in his records. He speaks to you through his records. And all of the experts, I ask them the same question every time. You have accepted Dr. Durrani's records as true to be able to give your testimony here today. Well, if they've accepted them as true, they know whether these people went through physical therapy or not, that they are doing awesome. They are doing well. They are doing fantastic. They are using all those adverbs and adjectives and comparisons that Dr. Durrani makes, because he's never had a surgery where he says after the surgery, you know, they're not doing well because I can't get them to go to physical therapy. It's not in any record. And not a single doctor on the defense side testifies to causation. They don't say anything about here is why they are not getting better. You get better with sciatic nerve pain, not only because we've released the pressure, but these exercises are designed to get the nerve moving through the foramen again, and without it, things won't heal properly. There's nothing like that anywhere in these records that would support it. And I would argue that it is very difficult, if not impossible, and that's why you never see comparative negligence in these cases. You're taking professional negligence, and then you're going to compare it to the ordinary negligence of a non-educated patient who is relying upon everything their doctor is telling them. And even though they want to differentiate between what's recommended and required, every time he mentioned post-surgical physical therapy in this courtroom this morning, he said the recommended. He didn't do the recommended therapy. Nobody criticized them for not doing it. Sometimes they can't do it.
Is there any testimony in the record by any witness that would explain causation in terms of the purported comparative negligence. So
No.
did anyone say these two individuals continued to suffer, they continued to have mobility issues because they didn't go to physical therapy as recommended?
Nothing, devoid.
How do you address the, also the argument of subsequent injury that happened to these plaintiffs?
Well, first of all, no one relates that subsequent injury at any level of preponderance for a jury to have decided that that disrupted the surgery itself. This is another recurring theme. Dr. Durrani, let's just say that he didn't have all the problems that bring us here. His goal is to get this person back to as normal a life as they can. They are not supposed to leave surgery, recover, wrap themselves in ashen cloth, and sit in their closet the rest of their life. They are going out to live their life.
I thought the argument was, and correct me if I'm wrong, that they went out and they started doing this active stuff before they should have.
That's their representation about the Bobcat.
Right.
But there's no causation. Nobody said that if the Bobcat accident would have happened 60 days later, he wouldn't have had those problems. People live their lives, things come up. We have patients that fall.
So if they had an expert that would testify on that type of causation, whether it be the physical therapy or the subsequent injury, then would you agree that the comparative negligence?
No, I don't agree that in a professional negligence case that you're going to have comparative negligence. Ever. Whether
Okay.
it's we're going to compare me to my CPA. I'm not a CPA. I've put myself.
Well, and aren't these claims, the crux of them is that the surgeries shouldn't have happened in the first place? And so isn't that really an all or nothing kind of claim? I mean, how do you pass off, like, the surgery shouldn't have happened, but you should have recovered better from it, and that's your responsibility?
Well, that's their position. Our position is that the surgery should have never happened, and everything that happens to these people, including ending up with a much more severe permanent injury, is the responsibility of the defendant. So you're right, it's hard to compare those apples and oranges in a comparative negligence setting, because one of the arguments that is made.
Let me rephrase my question just to make sure I understand. If a plaintiff who, let's just, for the sake of argument, agree, the plaintiff receives an incorrect surgery, they should not have received the surgery. If they make a mistake in how they recover, they make a poor choice, they don't follow the doctor's recommendation, are they responsible? Are they legally responsible for that choice? Or is that choice attributed to the professional who incorrectly performed the surgery?
It's absolutely attributable to the professional, because they would have never been in a position to disrupt the unnecessary surgery they went through and have an accident that broke a rod or a screw or pulled their fused spine into a pseudoarthritic condition, meaning that it's no longer fused.
The plaintiff can never be the proximate cause of their own injury at that point.
Not if it was an unnecessary surgery performed, and the argument they want to make is, hey, he had the surgery, we say he should have never had it, and now he's responsible to make sure he recovers exactly correctly from the surgery he should have never had, because he would never be in a position to exacerbate the issue that Dr. Durrani operated upon, the fixation of the spine. That's what they're talking about. They're talking about getting the maximum range of motion from Dr. Durrani having fused the spine, from having done a decompression. They're talking about recovering from the pain and the suffering over time. Well, they would have never had any of that. Now, he may have had that Bobcat accident and exacerbated his pre-Durrani condition if he had never had that surgery, but we won't know. That's completely speculative.
And no medical expert helped the jury understand that question, right?
Well, I think they do, because our experts testify that they shouldn't have had the surgery, that the surgery is the proximate cause of their injury, that when they have to have a revision, they would have never had to have a revision but for the first surgery, and they would have never had to worry about injuring the surgical site had they never had the surgery. Those are all the issues that you're bringing up, and those are all testified to by all of our experts. I mean, the whole case, when it comes down to like the billing, is that the second and the third surgeries for revisions, those bills would have never happened but
Did that
for...
happen in this case?
What's
Were-
that?
Were there multiple surgeries on these patients?
No, I'm just saying that those are the issues. She was asking me a generalized question about, would you ever be in a position where it would occur? And so I'm just saying that that is all part of how those things are presented by the experts in each of the cases. And so, yes, we cover that in every case, that everything that happens after Dr. Durrani's surgery that exacerbated the pre-existing condition is on Dr. Durrani, because he chose to do a medically unindicated, unnecessary surgery according to our expert testimony. Their expert testimony is that it's indicated, and then the jury makes a decision as to what they believe and what they don't believe. So, going back to the Rule 42 analysis for a second, as I said, the records are interchangeable, the same claims, the same jury interrogatories, the same jury instructions, other than changing she's and he's and names. And they talk about the different medical histories of the patient. There is testimony in every record where they want to try to bring up the medical history. Sometimes they go back 20 years. The problem is Dr. Durrani never looks at pre-existing medical records. He didn't look at pre-existing medical records in these two cases. He has never looked at them in 122 other cases. So this idea that they came to Dr. Durrani through different roads.
Does difference even matter under Rule 42? Are we even directed to look at differences in
No,
the
I think
factual background?
You're looking at whether there are enough similarities to consolidate. And this talk about where outside of southwestern Ohio do you see consolidation in medical malpractice cases? Well, other than Texas, and the only reason I know about Texas is Dr. Death on Netflix, who was a doctor butchering up people in Texas, and he did the 125 or 126 patients, and they did a series about it. Where do you find 540 malpractice cases against the same doctor? Now, where there were 7 in the case that this court decided, they consolidated them. And that was
Is there any limiting principle to this? So your opponent has argued that there has to be some limit. That
Well,
we can't just be, adding people's cases together ad nauseum, and that there should be some limitation on this.
The
Is there?
limitation needs to be left to the discretion of the trial court, and I'll tell you why. Judge, I've now tried Durrani cases in front of half a dozen different judges. Judge Reese, who is now pretty much it, we're not getting differences, has determined that 3 is kind of the limit. He feels from talking to juries after the trial and from sitting through more than 50 trials himself, that 3 seems to be the place that works.
Because it gets hard to differentiate at that point? Is that why?
Well, he's always concerned about that, and he asks the jury about it, but it's not on the record when he does. They have notes. This is all on the record. The notes are divided into sections for the 3 different trials or the 2 different trials, and the jurors keep track of all that. And I think you all pointed out the proof is in the pudding. They come back with different verdicts. You know, one case that I tried recently, one was 200 and some odd thousand, another was $1.9 million, and another $1.4 million, and another was 2.4, all in the same trial. Well, then
What about your opposing counsel's argument that looking at the punitive damages being exactly the same?
You took the words right out of my mouth, because that was going to be my next statement. Of course they're the same, and you know why? Unnecessary surgery. Convincing people to have a surgery that is not necessary, putting them through the surgical process, and then having them not only live with the disability that the surgery creates, because all spine surgery creates injury and disability, because you've disrupted the spine. If you fuse the spine, you've lost range of motion. The more you fuse, the more range of motion you've
Aren't
lost.
punitive damages really focused on the defendant's conduct and not necessarily the plaintiff's injury? I mean, they're designed to punish, right?
Well, right, but what the defendant's conduct is, under the definition, a reckless disregard for the rights and safety of another.
And could that have been in common?
That is common in the case because they're all unnecessary surgeries.
So would we expect to see variation across cases?
No,
And
you wouldn't. I don't even argue it that way. The argument is that these people went through an unnecessary surgery. Under the punitive damage statute, this is punishment for doing something intentionally wrong, and everything else that the jury instruction says about a message to the community. And we talk about the medical community, needing to know what happens when there's one bad apple in a bushel. They don't get to just act like the other apples. So yes, it's always similar. I think, the 180 some odd punitive damage awards are all identical. Now, the numbers vary, depending on what juries think is a lot of money or not a lot of money in Hamilton County. I mean, it could be as low as, $50,000 and as high as, I think, 15 or 18 or 20 million, just depending on the circumstances, the egregious nature of what they think they've determined and seen, et cetera. Now, I'd like to...
Counsel, you're out of time.
Okay.
Thank you very much.
Can I just say one thing?
Go ahead.
You were talking about class action cases, and I've done 50. The courts are usually looking for something more than 30, 35 together. And in federal court, we've tried 6, but it takes 6 weeks to try 6. So you've got to get jurors that'll stay for 6 weeks. And I think that's another consideration that Judge Reese has.
Thank you.
One bad apple in a bushel. Our system is built to make sure that even the bad apple gets a fair trial with due process. This court knows that well, and that's ultimately the issue here. No matter whether we like this apple or not, this apple gets a fair trial like any other apple in the bushel. Judge Bach, it took me a minute to understand where you were going, but yes, I do think this court could enter judgment if it excludes Dr. Wilkie. Dr. Bloomfield did not testify in this trial. That's inaccurate. And without Dr. Wilkie, they don't have sufficient evidence to show medical malpractice. So yes, I think Your Honor is right that you could enter judgment. Couple other quick things. Dr. Kalustian's testimony, it's at page 36 of our brief, 1216 to 1219 and 1250 to 1254 in the transcript, talks about the problems with not undertaking physical therapy and the potential long-term injuries that occur there. So that's where those items are in the record. Speaking of the record, most of what you heard was not in Appellee's brief, so we had no chance to respond to it in our reply. It also, in large part, was outside of any particular record. It was part of the philosophy of simply saying, lots of bad things happened here, so in this trial, find negligence.
What about the suggestion that we consider a data-driven approach to harmless error?
I think that is outside of how our constitutional process works and outside of how fair trials work, because in fact, this court has ruled in the collage cases that you're not supposed to bring in testimony of other cases to affect this particular case. You're not supposed to pile on just because they brought 500 suits. We have 500 suits because they brought 500, not because every single one has in fact been malpractice, as this court knows. In at least 2 of the cases, it was a different surgeon that the trial court was able to find liability for, and this court had to reverse. So lots of errors have occurred over time. This court has found them. A data-driven approach that looks at what has happened in other cases, I think, is absolutely inappropriate. I don't think you'll find a precedent for it. I can't think of one, although I haven't researched it, because it's then judging, it's not giving the bad apple, so to speak, the fair trial that even the bad apple is entitled to. And so I think it'd be very problematic. And if we're going to go outside the record and talk, you had a lot of questions about whether Dr. Wilkie could testify now. If we ended up bringing public records to this court about things like that, we would bring public records giving you, I think, a pretty clear sense that Dr. Wilkie isn't cooperating with plaintiff's counsel anymore, and there are records in the courts in Kentucky that could explain why. So as to whether Dr. Wilkie might someday be able to testify under the new statute, that's a lot of speculation. That's why we don't go outside the record. That's why appellees are required to bring their arguments in their brief and not make them for the first time at oral arguments, so that we have a chance to respond. Yes.
Back to Dr. Wilkie in September 2021 was the trial.
Yes.
After Dr. Wilkie lost his position when he was practicing and then he was working for the insurance company, did the plaintiffs have an opportunity to find a new expert? Do you know the answer to that?
Yes. I mean, they certainly had time to, if they chose to stick with Dr. Wilkie. They also could have asked for more time to find, right? I mean, trial, if something like that were to happen, I think trial courts often use their discretion to give somebody more time. There might have been.
If I'm recalling correctly, wasn't this issue about the clinical practice standards raised by a motion in limine pretrial?
Yes.
So they had noticed that this was an issue with regard to the expert?
Oh, absolutely, yes. Those are my, I think I've hit all the, in terms of whether comparative negligence is ever an instruction in a medical malpractice case, we cite the Faber versus Syed case. It does come up. The general concept that you can't have comparative negligence in a medical malpractice case is contrary to Ohio law. So you can find it in cases like this.
Are those cases of the ilk where the surgery is contraindicated or where the surgery is negligently performed?
So in the few cases where it has come up, I don't think there was any that it was contraindicated. And they weren't necessarily surgeries. In one of the cases, someone argued that the fact that the plaintiff was unhealthy to begin with was the comparative negligence, and that was correctly struck. That is not the argument we're ever making here. What we're saying is, post-trial, we have expert testimony that says you should have done the physical therapy as recommended by your physician because that would have helped prevent stiffness, to improve the injury, to build the muscles, and to allow them to heal properly instead of getting back to work in jobs that caused additional back pain or having a bobcat injury, things like that. So we think it should have been appropriately given here. We think there is sufficient evidence for it to have been given. That is not the reason that the trial court didn't give the instruction in the first place. It just said it wasn't gonna. And so we think it was appropriate. We think there are a number of grounds for this court to reverse. There was no harmless error. Again, appellee makes no harmless error argument in their brief. And if you find that Dr. Wilkie's testimony is sufficient, you can enter judgment in favor of defendants in this case. Thank you for your time.
Thank you. Thank you both for your arguments. We will take the matter under submission and issue a timely written decision. Enjoy your day.